All right. Welcome back to The Lawyer You Know. Back talking about R. Kelly. It's probably the penultimate or second to last video we're going to do on R. Kelly, as the judge expects to hand the case to the jury tomorrow at some point. So the jury will deliberate. I hope they don't come back within one day with this complex of a case and this many witnesses in this many days. So we'll expect a verdict at some point next week, and we will try to jump on a live as quickly as possible once we hear the verdict, so that we can kind of talk through it together as we've done throughout this journey. So many videos talking about R. Kelly, talking about all the witnesses, and talking about everything that's happening at this trial. So thanks everyone for joining in on this live. Make sure you subscribe to our channel because I want to know what's next for you guys. I know you're interested in this R. Kelly case. You can check out our page and see all the other cases we're already currently breaking down, but let me know if there is a next big thing for you so I can try to dive in and see what's going on with that case and what it's all about so that we can talk through it further and I can give you how the lawyers are breaking it down on each side. And it's cool because my firm, we have lawyers that have been public defenders, state prosecutors, federal prosecutors, military officers. So we've got a really diverse background of different ways we can talk about different cases. So whatever it is you guys are interested in, that's what I want to know. So let me know in the comments so we can track that and try to bring the content that you're interested in. So make sure you subscribe during this video because there's not going to be a ton more R. Kelly videos for you to watch, and then start subscribing and following our channel. And if you like the R. Kelly content, as always, like the video because it helps us know who likes R. Kelly and who doesn't. Not who doesn't like him personally, but the content. So as always, the way we're going to do this video is I am going to talk through kind of the last couple days of witnesses, which is right as the prosecution's closing their case in chief. And then we'll talk through the entire defense's case before we ultimately talk about the prosecutor's closing argument, which just finished today around 12:30. So we don't have a indication of as to what the defense argued, but based on the prosecutor's closing argument, we already know what the defense is going to argue. And you can kind of see the themes throughout the trial, and we'll kind of talk through how the prosecutor did it and what some of the reviews are. What's up, Dom? What's up, Progress? Glad you're here. Glad you're a new viewer. So, and again, I probably won't follow the chat the whole time I'm talking because it's hard to do both. But I will get to as many of the questions as I can. If I don't see your question, I apologize. The super chat questions get highlighted, so I make sure I get to those. But I'll try to get to as many of the questions as I can at the end. So let's just get through the witnesses here. This is my least favorite part, but some people like it. I don't just like regurgitating the facts of what I've read and what I've seen about the witnesses. So the first witness that we haven't talked about yet was a former assistant. This was, again, called by the prosecution. She did not want to be there, so she still kind of was fond of R. Kelly, still had business dealings with R. Kelly. And she did talk about how she had gotten some strong, serious warnings from R. Kelly in the past because there was a 17-year-old at some point that was a rapper / aspiring artist who R. Kelly worked with, and she connected them. They called her the assistant sometimes, then other times she was seemed like a talent manager of some sort because she was connecting R. Kelly with other musicians. And this 17-year-old was going to sue R. Kelly for inappropriate behavior and basically inappropriate remarks and physical advances in the workplace, right? So that's this 17-year-old was going to sue R. Kelly for. It turns out it resolved. But R. Kelly said, choose her or me, sign here on the dotted line saying you never saw me do any of this with her, and tried to force her, London on the track. But so there was a bunch of discussion about whether or not that actually happened, and then R. Kelly forcing her to write letters and Criminality Online. Thanks for subscribing. So the letters she was forced to write, kind of similar to everybody else, forced to admit wrongdoing, forced to admit or take allegiance with R. Kelly and basically say, I'm with him, I'm ride or die with him, which is how he made everybody do. She testified that Rob had a lot of female guests and they had these rules. You know, we don't need to belabor it anymore. Anybody that's been following the case has been listening to my videos. A lot of similarity and a lot of differences, but a lot of similarity through the rules, the embarrassment, the domineering over them that all these witnesses were trying to say that R. Kelly did to them. She said she quit because he yelled at her in a McDonald's for ruining a birthday party. Again, what does that have to do with anything? I don't understand some of this totally irrelevant information that comes out, like he screamed at her at a McDonald's. Why does that show as criminal enterprise? I don't know. So then she talked a lot about the non-compete and little things that she had to sign here and there, or not the non-compete, the non-disclosure agreement that she had to sign, and the agreement basically saying that he didn't do anything wrong, and the letters that he wrote or that he forced her to write and that he actually dictated for her to write, right? And they said on cross, she almost fainted in the courtroom during cross. So you tell me, as a lay person that might be sitting on a jury one day, what would that make you think if somebody was perfectly fine during direct and then they almost faint during cross? But during cross, they're like, okay, we've heard from a lot of these women that were 16, 17, 18, 19, 20, 21, 22 years old at the time of their interactions with R.Kelly. And, they're saying they didn't know what was going on. They did whatever he said, right? But this is a person that was in her 40s getting paid 10 grand a month from R.Kelly. And she was in this music industry working for other artists, connecting artists, making good money. Yet she was saying, oh, I didn't know what I was signing. I didn't read the whole thing. I didn't ask a lawyer what it said. And we're just supposed to believe that R.Kelly forced her to sign and she just signed it. That wasn't very powerful to me for this witness in particular. Lots of people sign things without looking, without reading, without talking to a lawyer, even though they shouldn't. Like literally anything you sign, you should read and know what you're signing. But even less of a viable explanation that she said she signed these documents because of her age, experience, the amount of money she was making, and things like that. She also signed this is what it was about, a pre-written affidavit. And she said, I signed it without even reading it, but saw that it said Rob never gave anyone alcohol or directed them to perform physical acts. So she's saying she's sitting here signing affidavits under oath, under penalty of perjury with criminal sentencing hanging over her head, and she didn't even read it. As somebody who's worked in the industry for years, that's an issue, obviously. All right. So the next witness, which we have talked about as a group throughout these videos, was a clinical psychologist, okay, Dawn Hughes. We knew this was coming because a lot of people were talking about why did it take so long for the women to come forward? Why didn't they come forward earlier? Why did they wait till the documentary come out? Why did they wait till other victims came out? Why did they wait till they thought he was paying money to some of these victims to come out? Well, she, as far as it seems, did a good job answering a lot of those questions. She said that she's basically an expert in physically unhealthy relationships, okay? And she spoke about grooming young girls, how they cope. It's not unusual for people like Rob to have underlings doing his bidding. Directly connects to the criminal enterprise they're trying to prove. Not unusual for people. It's not unusual for the women to keep coming back if they're abused. It's been a huge question throughout our chat. Why do they keep coming back if they're abused? She said that's normal for women that are under physically abusive and physically unhealthy relationships. Young people, she focused on, are influenced by powerful people. This abuse is not just an event, it's a pattern, not just a single incident, but a process. These are some of her quotes. Again, I think this all is adding up to a criminal enterprise and racketeering, right? She is an expert witness paid for her testimony. So that's important that she seemed a lot more polished, able to connect these dots a lot more than a lot of the lay witnesses or the alleged victims. She is a clinical psychologist expert focusing and experience in this specific field. And she focused on young people. She focused on powerful people. She focused on money. She focused on physical abuse. The victims rationalize ill treatment and disassociate. They don't believe they can safely get away, especially if they're isolated by their family or from their families. So, isolated from their families, that should ring a bell. A lot of them said they were isolated from their families throughout this entire process. Youth, that should ring a bell. A lot of them were saying they were young, even if they weren't minors, still young. And then physical abuse and emotional abuse. Again, we heard a lot of testimony about physical abuse and emotional abuse, right? So all of her expertise and her testimony was hitting those points, right? And then the prosecution rested its case on Monday of this week. So the defense gets to start its case and put on its witnesses. I think the prosecutors had 19 or 20, I'm sorry, 45 witnesses over 19 or 20 days. I think there was about 11 victims. I just read this and I can't remember. There's so many numbers going on. 45 days, 19 or 20 witnesses. I think 11 victims, 2 John Does, 9 Jane Does, plus a bunch of former employees, experts, law enforcement, throughout their 20-ish days of trial. Then the defense basically had a day or two where they did their case. Now, they weren't limited to a day or two. That's just what they ended up doing. I think they called 5 witnesses. And a lot of the articles that I read with some of the transcripts in them, some of the highlights from the transcripts, called the defense witnesses loyalists. R. Kelly called loyalists to the stand. So there was a longtime friend, invited him to stuff for 15 years, was constantly around R. Kelly. A lot of similar themes here. Oh, I was around him around the clock, nonstop, saw everything he did. He never treated any of these women poorly. He never committed abuse. He was chivalrous to them. Some of them went a little overboard, in my opinion. Now, this guy, the first one, was never on Rob's payroll. I think his name is Danny Robinin or something. He never saw him mistreat the women. He wanted to play a song that he and R. Kelly made, but the judge would not let him play that song. None of the songs he made with R. Kelly actually made it to the radio, I guess, and they never made any money off them. Very weird stuff. I don't know why this came out. I don't know why he wanted to play a song he did with R. Kelly. Seems weird if I was the defense. Now, sometimes defense attorneys like to do stuff like this where they say in front of the jury, which I don't know if this was in front of the jury, but Judge, can we play the song that R. Kelly and I sang together? Objection, Your Honor, from the prosecution. We all go up to sidebar and whisper for a little bit. We come back and sit down. The judge says they can't play the song. Now the jury's thinking, why did the prosecution object? Why didn't the prosecution want us to hear this song? And doubt can creep into their mind based on something that was just put in front of them, objected to, and they never actually heard it. So sometimes it is part of strategy for a defense attorney to try and do stuff like this, even knowing it's not going to come in, right? What would you think in the chat? Let me know. What would you think if I'm the lawyer, my witness is talking, an objection comes to something that he wanted to produce for the jury, judge says he can't produce it. Are you wondering what that is? I think just it's commonplace and normal for us to be curious and to wonder what that is. And maybe that's one of the reasons that the defense did this. Now, on cross, which is a similar themes throughout cross of all the defense witnesses, the prosecutors asked, were you with him 24/7? Were you with him when he was alone with the women? Were you even in the same place as a lot of where the women were? And the answer was no, 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 no. Basically, they were making music. They were in certain parts where the women would be around, but he wasn't alone with R. Kelly with the women. And a lot of the women would be in the house or the hotel or the Trump Tower. And R. Kelly would go to them without him, tour bus, whatever, and he would not see them when they were alone together. And then bias is a big thing with every witness. And with the clinical psychologist, the defense asked, were you paid for this? Is this your job? This is what you do for a living. You testify, things like that. Well, the prosecution also tried to show bias with each one of the defense witnesses saying things like, it would be bad for you if R. Kelly went to prison for this, right? Because you're making money off R. Kelly. You're connected to R. Kelly professionally. And a lot of the witnesses said yes. Okay, another witness was a childhood friend and part of the security team for R. Kelly. And things got messy quick as the witness stumbled over whether or not he had lied previously in court, because it turns out he had been convicted for perjury and forgery in the past, I believe. He was a police officer at one time in Chicago. And he talked a lot about how, oh, I was with R. Kelly all the time and I never saw anything inappropriate, because if I did as a police officer, I had a duty to report it and I would have reported it. And he also said that he left under good circumstances from the police department. And I think it's obvious why the defense would want to call somebody like this, right? Because at least in a past life, jurors usually believe what police officers say. Police officers can usually be trusted. And so that's why they want to call this police officer or former police officer to the stand, because the jury would believe what he said. However, kind of like the pastor that the prosecutors called, right? You would think a pastor could be believable, but on cross, they beat the pastor up. And on cross here, they beat the police officer up because he pled guilty to forgery felony forgery charges and using fake bills. And they said, isn't that why you left the police force? They got into his plea deal, which a lot of people don't know that. But if you plead to something in open court under oath, you can be impeached with that. Meaning if you say something that's contradicting what you said in that plea deal and you're a witness in a case and you say something different than that plea deal, they can then bring it up and say, you knew they were forged bills. You did this with those bills. You pled guilty. You said, I did it. You said, I learned from my mistake. So you can't be wishy-washy and say, I think he said, well, I didn't know the bills were forged. And he tried to be a little, wishy-washy about it. No, they can impeach with what you said at your plea agreement. That's something a lot of people don't know. For any felony or crimes of moral turpitude, which basically means crimes of dishonesty, fraud, forgery, perjury, things like that. All right. Then we also heard some rumblings throughout the week that R.Kelly was not going to testify. The judge basically said, let's hold off. He has until closing arguments start, till the defense rests. So let's hold off. They did the colloquy with him, asked him all the questions, make sure he's doing it of his own volition, which is not surprising. If you listen to our other videos, we didn't think he was going to testify. The only reason we thought maybe is because he thinks he can get himself off like he did with that Gayle King interview. But the lawyers are probably telling him that Gayle King interview did not go as well as you may have thought it went. So he seems like he's not going to testify. An accountant also testified that worked for Rob. He cut the checks for Rob. He knows that Rob would walk around with backpacks full of money when he would take the women on shopping sprees or wherever he would go with them. He would just have backpacks full of cash, literally, and drop the bag with them whenever it was necessary. Let's see here. He met with Rob multiple times a day, 12 hours a day. Again, they tried that similar theme. I was always with him. I saw him all the time, and he was super nice to all the women, and I never saw any inappropriate conduct. Another former employee said he never saw underage girls around, never saw them mistreated. If they wanted to leave, they were allowed to. And again, on cross, it would be bad for you if something happened to R.Kelly. It would be bad for you if he went to prison. It would be bad for you. It would be a mark on your ability to make money. And he said yes, again, showing bias. Another associate said he was with Rob all the time, no mistreatment. He was chivalrous. This one went a bit far, in my opinion. But all of his witnesses were consistent in the fact that these women could leave whenever they wanted, which seems to be a consistency with the prosecution's witnesses. So that's a pretty strong argument about they were not kidnapped. They did not have to stay there. They were not trapped there. They were coming there consensually under their own volition, at least the ones that were adults and able to do so. So I do think that was a common theme throughout the defense witnesses. And then the other associate that said he was with R.Kelly recording all the time, on cross, again, they said that he was biased, but they also said the witness is based in California, right? Not Chicago or Atlanta, where R.Kelly, a lot of this stuff was happening in Chicago and Atlanta. So that was also a knock on him in cross. Okay. So that was basically the gist of the defense's case in chief. So they called 5 witnesses, I believe, accountants, former employees, friends, security, to say that Rob was basically a good guy, didn't mistreat these women. Then the defense rested their case, and the prosecutors did their closing argument for almost 2 full days. But you can imagine, 45 witnesses, 20 days. There's a lot to go over. A lot of people don't know this, but judges will ask at the beginning of trial, how long do you need for your closing argument? And we have to try to guesstimate based on the evidence, based on the witnesses we're going to call, how long our closing argument is going to be. And a lot of times the judge will hold you to that, especially in federal court. They will limit how long you have for closing argument, especially if the judge is getting annoyed with you, or like some people think the judge is, a little against the defense, but both sides get equal time, right? They can't give the prosecutor 5 hours and the defense 3. So however long the prosecutor took, the defense attorney is going to get the same amount of time. What's interesting, though, is the prosecutor can split their closing. They can go first and last, and they always do. At the end, it's called rebuttal. Okay, so it goes, the prosecutor does their first close, defense does close, then prosecutor does the second close or the rebuttal. And if they have 5 hours, they can do 2 hours in the front, 3 hours on the back. And the defense has to do all 5 hours in the middle. The reason for this is the prosecutor has the heavy burden. Especially in criminal cases, they have the heaviest burden in the land beyond a reasonable doubt. And because of that heavy burden, they are allowed to speak first to the jury and last. So when opening statements happen, actually even when voir dire happens, prosecutor goes first. When opening statement happens, prosecutor goes first. Closings, prosecutor goes first and last. That's just the way our criminal justice system is set up. Let me know if you think that's fair, or if you think it's unfair and you think the defense, because they have constitutional rights, they're the one whose life is on the line, if they should go last. Let me know what you think. All right, let's see here. So, LaShonda, I just happened to see your question. How do we know how long they have? We wouldn't. Usually that's agreed upon beforehand. The jury doesn't know. The public usually doesn't know. We say that outside the presence of the jury. That's part of our housekeeping stuff we do at the beginning of trials. All right, so let's talk a little bit about the prosecutor's closing. And I wanted to read some quotes. I also wanted to read, so for the first time in my kind of assessment and looking what's going to happen, I'm trying to look for mostly for transcripts, for specific quotes. I'm not looking for a lot of people's opinion on it at this point, but I did want to hear some people's opinion on how they think the prosecutor's closing went, okay? And most people said it was very thorough, but it was repetitive and into the weeds and maybe a little bit boring, right? So they said that the prosecutor in the beginning did a great job of the heavy hitting summary. It was quick hitting, to the point, got the main theme across. Then the prosecutor used quotes like, let's rewind a little bit, let's back up a little bit and talk about this. And the racketeering charge that I think had 14 different racketeering acts in the RICO charge, and she went through every single one and how the testimony and the evidence proved each and every one of those. It was laborious, but she felt like it was necessary to prove every single one. After 20 days of witnesses, she wanted to make sure the last thing the jury heard and saw and thought was her words explaining how the evidence pointed to guilty on every single one of these underlying acts to the racketeering charge, right? So that's important to her, and she did it. Let's hear some of the quotes here that I pulled out. For decades, the defendant recruited and groomed women, girls, and boys for his own sexual gratification. With the help of his inner circle, he slowly isolated his victims, set rules, and exacted punishment. Okay? This is how you see she's focusing on the big picture, RICO, racketeering, criminal enterprise, not just individual acts. It's time to hold the defendant responsible for the pain he inflicted on each of his victims. And she went through each of the victims' name. It's now time for the defendant to pay for his crimes. Convict him. Let's see what else we've got here. The defendant used lies, manipulation, threats, and physical abuse to dominate his victims. He was able to hide in plain sight because of his wealth and fame. His inner circle served as enablers for his criminal conduct. She talked a ton about his inner circle, because that's how you build the enterprise. That's how you pull in everything together, regardless of any statute of limitations, and you prove this RICO charge. When someone commits a crime as part of a group, he's more powerful and more dangerous. Without his inner circle, the defendant could not have carried out the crimes he carried out for as long as he did. She really did a good job honing in on a lot of the questions we have. How is this a criminal enterprise? How is this RICO? How is this racketeering? Well, she did, apparently, from the reviews of people that were in there and what I'm reading from these quotes, did a good job of trying to bring it all together and synthesize it and summarize it for this jury to understand how this was a criminal enterprise. So when some of these women arrived in Chicago, it wasn't like they imagined. Some of their big break turned into their worst nightmare because of the defendant, right? So those are some of the quotes that she gave, and eventually she ended her closing argument, right? Her first close, but we will be hearing from the prosecution again in rebuttal. So what is left to happen in this trial is the defense, and it's probably happening right now because the prosecutor finished the first close at 12:30 today. So what's probably happening right now is the defense attorneys are giving their closing argument. It'll probably bleed into tomorrow. Prosecutor will give their second close tomorrow, and the judge will charge the jury. And what that means is the judge will read the jury their jury instructions, which means go back there, look at the evidence. You can only look at this evidence. Don't look at anything online. Don't talk to anybody else about this. If you need something or have a question, let us know. We can ask a jury question. We can see if the lawyers can provide that to you. If you want to bring the tapes back with you or pictures or anything like that, or the shirt, you can bring that back with you and look at it yourself. This is where the jurors are the fact finders and come up with their decision and their verdict in this case. The judge reads them a bunch of instructions. And what's cool about it as a lawyer, we have all these instructions. We actually agree to these instructions. Both lawyers agree to the instructions that the judge is going to read the jury. We get to use them in opening statements and closing arguments if we want, because then it seems like the judge is telling you exactly what I told you. I said, don't look at this, do look at that. I said they have to prove this exact word in the RICO charge. They did not prove that word. Listen for when the judge reads you this jury instruction, listen for this word. And remember that none of the women said that they could not leave. None of the witnesses said that they were stuck there. They could leave whenever whatever it may be. You as a lawyer can pick out specific words and phrases in the jury instructions and be reiterated by the judge. And that is huge because the jury trusts the judge. The jury likes the judge more than the lawyers usually. The jury doesn't think the judge is trying to sell them anything. The jury just thinks the judge is there to be fair and make decisions. It is the judge's courtroom. So if the judge is going to read instructions and you as a lawyer can reinforce them, that goes a long way. And a lot of people that haven't sat on juries or been in trials don't know that, but that's why a lot of lawyers focus on the jury instructions, and they also focus on the verdict form. So we actually have where we check the box for not guilty, or we check the box for guilty if we're a prosecutor. We go down every single word, how we proved it. But just like we've been talking about throughout all of our videos, do you think the prosecution overtried this case? Did they call too many witnesses? Did they call too many witnesses that were not as strong because they had lied in the past, or they were biased, or they had inconsistent statements with other statements they had made on documentaries or even to the prosecution? And should they have just stuck with 5 or 10 of their strongest witnesses, maybe only 5 or 6 victims and then 5 or 6 other witnesses as opposed to the 45 that they called? Or is the only way they get to RICO is to stack all this negativity on R.Kelly to say he's a bad guy? Who cares if we prove the charges of RICO? Do you really want this guy to go free? Prosecutor can't say that, but they can put on evidence that basically says that to the jury. And a lot of us have kind of thought that might be what they're doing. And that might be the best way for them to convict him, is to not stick to the RICO charge, but just try to pile on with everything they could, every witness they could, every piece of evidence they could. All right. So we're going to get to some predictions. And my prediction, I don't know if you're going to like it or not, but we'll get to my prediction at the end. I want to hear some of your predictions. People have been talking the whole time. It seems very strong from the beginning of the trial. Before anybody even heard a witness, a lot of people had their minds made up about this trial one way or the other. But I'm going to get into the chat now. So if you have any questions about anything I explained, about the process, about closing arguments, or about this trial, get in the comments now, because I'm going to scroll through and I'm going to try to answer as many of them as I can. All right, let's see here. So yeah, LaShonda, we answered this. How do we know how long they had? We did not know how long they had. So some people saying they think he's going to be acquitted. Sean Barron, the judge is against him. She would let the government close for 10 hours. Well, if the government would have gotten 10 hours, the defense attorney would have gotten 10 hours as well. Jessica Alter, yes, we are. If you go to our page, we've done a couple videos on it already. My partner, Pete Sardis, I think did these at least 2 videos on this Tristan Bailey case. So we are covering that as well. So Miss Dondon, do you think he's innocent or guilty from the evidence you have heard? I'll get to that at the end, but it's not innocent or guilty, which is good for R.Kelly and other defendants. They don't have to prove he's innocent. It's either guilty or not guilty, which I'm sure you know, but I just figured I'd point it out. So LaToya, the prosecution took too long. And that's something I'm interested in, to see if people think that. Like, I think it probably cuts in the defense's favor that they had a short case in chief, and they can say things like, we didn't need to call 50 witnesses to say the same thing. You get the idea. We could have called 50 witnesses to say Rob's a great guy, but that would have been a waste of time. All right, so Mrs. Cece, I'll try not to make it too much of a TED talk. Is the heavy burden also the reason why they're able to submit the different motions and or requests in the last days? So no, it's not supposed to be. We're supposed to have equal, the prosecutors and defense attorneys are supposed to have equal access to the court where it comes with following the rules, right? And the deadlines. However, it is totally unfair in certain circumstances, not just this case, where at the very last day, the prosecutors can change the date range that a crime was committed, which totally changes all the discovery, all the depositions we've taken, because we focus on asking questions about certain date ranges and certain times. We've come up with alibis to prove the defendant couldn't have been there in those date ranges. Now all of that changes 2 years into litigation when we're supposed to go to trial. The prosecutors can file motions at the last minute and they don't get stricken. The judge will let them in and say, well, if you want to continue the case, you can, because it's our client as defense attorneys, our client's life that's on the line. They're sitting in jail for years and years. So the prosecutor doesn't care if the case gets continued. They just move on to the next one. So yes, it is totally unfair in certain circumstances. And that's why I get very frustrated sometimes with our criminal justice system, that I think prosecutors need to be held to the same standard and rules as criminal defense lawyers. And I think it's very unfair sometimes, the leeway they're given to change certain things at the last minute, where continuances hurt defense attorneys a lot more than they hurt prosecutors for the most part. So Sultry saying Kanik is killing their theory on closing. So that's the defense attorney, and we'll see how that goes. I haven't gotten anything from them yet. So Lauren S., yes, I think we will be covering the Kyle Rittenhouse trial. It'll depend on you guys. If you want to hear it, if you want us to talk about it, that's how we get most of our content, is we listen to you, whoever's listening, whoever's liking, whoever's commenting and chatting on these videos. That's where we get a lot of our content, and that's what we choose to cover. We don't necessarily choose what we want to cover because it's all interesting to us. So Urban Opinionated Podcast with Ira. This is a trial about emotions versus facts. I think there's a lot of emotion in this trial. I do think there are some facts too, but I think the emotion is potentially going to carry the day. And I think that's what the prosecutors really focused on. All right, I'm looking for questions here if you guys have them. So new Chris, cameras aren't allowed in federal court. It's just one of their rules. It's federal court. It's big boy court, as we call it. The why is because they don't have them. It's not like most states have, like Florida, the Sunshine Law. It's a right for us to have public access to the courts and to see it as citizens of the state. It ain't the same in federal court. So JD, I think she went on too long and the jury fell asleep. So that's interesting. We'll see if that's true. Stars, News, and More. I understand what you're saying. You wish I would have waited till after Kanik's closing argument. My schedule is not always perfect with how the trial goes, so I try to fit these into my schedule as much as I can. I am a full-time, full-load, real lawyer still with a full caseload, practicing mostly personal injury and some criminal defense. So I fit it in when I can, and I figured I'm still going to do one more after the verdict comes down so we can talk through Kanik's closing argument after we see the verdict, and then we can have some hindsight, being 2020, and we can look back and say, wow, it was a great closing, it worked, or even though it was a good closing, it didn't work. Let's talk about why. Mrs. Cece, when you say change the language, what do you mean? Do you mean like change it from English to Spanish, or do you mean change it from they to their, or things like that, actually changing words and verbiage? If you mean changing language, obviously, yes. If any of the jurors, it'd be hard though for the jurors that would have headphones if they were a different language. I didn't see that any of these jurors were, but in some cases we have had, like we've tried some Chinese boat cases where everything is done in different languages and everybody had to have headphones on and listening to it being translated, which was just insane. My partner, Pete Sardis, was the lead trial lawyer in that case, and it was in federal court, and it was just insane. He represented one guy of 25 guys that were charged in this big boat case. So they can do stuff with the actual language, if that's what you meant. But if you mean like verbiage or different words, yes, they can change the verbiage in the jury instructions, but the lawyers have to agree. And if they don't agree, they put 2 up to the judge, and the judge decides which one to go with. Usually that doesn't happen. Usually the lawyers can agree because there's case law saying this jury instruction is fair, this one is not, this is what's used. This is not the first RICO case these people have tried, especially this prosecutor. She's been doing RICO cases in New York in federal courts for years and years. So she knows what jury instructions are normal for these cases. They don't usually reinvent the wheel. Yeah, Ray Black, Stockholm Syndrome, can't leave. All right, let's see what else we got. Sydney Dennis not guilty, as that is the reason the prosecution was trying to change the jury instructions. I'm not following. So Mike J. Prosecution didn't do a good job. They're trying too much, trying too hard. That's how you know they don't have evidence on R.Kelly. I think there are some people that are going to feel that way. The prosecution tried too hard. They called too many witnesses, too much repetition. To me, that's where, I mean, we've seen in other cases like Bill Cosby's first trial. They didn't let them call all those victims because it was repetitive, it was prejudicial, it was cumulative. And I think that's going to be a big issue on appeal if R.Kelly loses. Was this evidence cumulative? I'm sure they made those objections and filed those motions pre-trial. So Mr. 444 Smile, can this all be overkill? Sure. It's up to the jury as to whether it's overkill or not. A lot of people saying he's guilty. A lot of people saying he's not. So Keenan Craig, I have seen some of the transcripts. But I do not have time to read all of them. So I'm not going to sit here and pretend I've read 4 weeks of transcripts. All right, JD, I think the prosecution will not want to be walking away with something, but from where I am seated, they have not proven RICO beyond a reasonable doubt, so not guilty. Okay? Sultry, not guilty. They didn't prove anything except R.Kelly having sex and consent with consenting women. Okay? So common sense conversations. Funny that you also have common sense in your question. Do you think the jury is going by law, or was the prosecution witnesses so horrible they're going off common sense? So I don't know what that would mean because the prosecution witnesses are so horrible they'd go off common sense. But I think the jury is going to follow the law. That's what I hope they're going to do. Usually they believe the judge and listen to the judge and focus on what the judge says. And the judge tells them to follow the law and see if they have proven this case in front of you, not anything else. Don't take any emotion into it. Don't take any sympathy for any of the witnesses or victims into it. You have to follow the law and see if the charges were proven as charged. All right, so Mr. 444 Smile, I say 50-50. So usually 50-50 would lean in either a hung jury or not guilty verdict. So Jen Brown, I'm not a prosecuting attorney anymore. I was in the past. And we have some lawyers in our firm that were as well. I'm a defense attorney now for the most part. I mostly do personal injury, car accidents, slip and fall, stuff like that in Florida and across the nation. But we also do criminal defense as well. And our firm does a lot of criminal defense. Merge music and film. I don't like making light of stuff usually, but with R.Kelly, so many lyrics come to mind when I think about this case. So I'll let you quote it, not me. He said, do you think R.Kelly's attorneys will sum up the defense by saying there ain't nothing wrong with a little bump and grind? All right, let's see what else we got. So Jessica Alter, can he still be civilly sued for this stuff by these women/men if he is acquitted? The answer is yes. Criminal acquittal does not preclude you from suing in civil court. There are totally different burdens. That's why I say this is the heaviest and highest burden in the land. beyond a reasonable doubt, because civil burdens can be clear and convincing evidence. They can be greater weight of the evidence. They can be more likely than not. It can literally be 50.1% to 49.9% is all you have to tip the scales to win in civil court. But beyond reasonable doubt, it's a much, much heavier scale that they have to meet. So yes, one does not preclude the other. You can win one and lose the other, or vice versa. Okay, prosecution will not be wanting to walk away without a conviction. I know you guys are typing fast, so no harm in a couple typos. I try to figure out what it means. So Mr. 444 Smile, do you ever need this many witnesses to convict anyone? Our firm has had trials that have lasted 4, 5, 6 months. So yes, sometimes you do need this many witnesses. So Jackie Burns, Diane even said R.Kelly was angry with her that she let one of the girls escape. Escape sounds like being held against their will. I agree with you. Escape does sound like that, but I think there's some contradicting evidence, because a lot of the women said they could leave whenever they wanted to, and a lot of the employees said they could leave as well. So loving Mr. Kelly YTF, we don't preclude who we defend based on what people say about them, or even based on their guilt or innocence. We defend a lot of people that some people would think are horrible. We've been called things before by who we've defended, but we believe everybody deserves a full defense and their constitutional rights should be protected. So yes, we would have defended R.Kelly. Now we don't, and I'm not saying R.Kelly's doing this. The only reason we wouldn't defend somebody is if they wanted us to commit crimes. They told us they were going to commit crimes in the future. Or they wanted us to lie in court, or wanted to perpetuate a lie in court with witnesses who they knew were going to lie and we knew were going to lie. So we won't do any of that, anything unethical like that, but we represent anybody that deserves a defense. So Ms. Dondon, I may have missed this. What will happen now the prosecution is refusing to allow the man who wanted his sentence cut by testifying? So they didn't call him to testify? Because a lot of times they can renege a deal if they don't use your testimony and if you don't help in their case. It is usually contingent on your testimony if you're going to cut a deal and become a witness for the prosecution. What happens when the courts misinterpret / break the law? Karma Lee. When you say the court, usually from a lawyer's perspective, that means the judge. And if the judge misinterprets or breaks the law, a couple things can happen. If they break the law, obviously they can be criminally prosecuted. If they misinterpret it and make a mistake, they can be overturned on appeal. So if the judge made any reversible errors here, the appellate court will look at it and they can reverse this case. They can remand it back for another jury trial. They can throw out the charges. There's lots of things they can do if the court misinterprets the law. If the jury does, it's much harder to prove, because what happens in the jury room is sacred. So we don't know if they go back there and say, my sister was raped by R.Kelly, I'm convicting him and you all should too. A lot of times we don't know that unless one of the jurors tells us or tells the court. So the jury room is sacred. A lot of times we don't know what happens behind those closed doors. So if the jury misinterprets the law, a lot of times there's nothing we can do. So home-based media, I don't usually like to say things like this. Do you think if you were on the case, you would see more success with this case as a prosecutor or defense attorney? Thanks. I don't like to say stuff like this. I would never say it again. Well, I shouldn't say I would never say it, because there are some really terrible attorneys. But a lot of it's done in the pretrial phase, right? Like when I look at this case, I'm sure the defense did, but I would have fought hard to keep a lot of this out. I don't think a lot of this is relevant to Rico. I think the evidence is really cumulative. And if they did fight it properly and they lose and he's guilty, I think there's going to be some great issues for appeal. So I wouldn't say that, I would have done a much better job here or there. I think I could convict R.Kelly as a prosecutor. I'll say that. Will you update the ever-changing Murdaugh case? Yeah. So that didn't get a lot of run on our page. We did a video on it. And if it gets enough interest, I'll definitely do it. It takes time to dig into these cases. So I like to use my time wisely and try to hit as many viewers as I can and what they care about and want to hear about, not just what I care about. That is incredibly interesting to me. So go check out our video on the Murdaugh case if you haven't already, and let me know if you want to do more. So sultry speaking, if the witnesses committed perjury and are not charged, that means they had immunity. So when you say perjury, do you mean perjury while testifying in this case? Because immunity does not cover perjury in the case in which you're testifying. Usually immunity will cover things you've done in the past and things you've done connected to the defendant that you're testifying against. If I took a bribe from you and I'm testifying about how you gave me a bribe, usually my immunity is so I'm not going to get arrested for bribery and being involved in bribery. It doesn't protect me from all the crimes I've committed in my life, and it doesn't protect me if I lie in court that day. So no, perjury is not protected by immunity. So Naya X, yeah, the judge can give guidance. Oh, change the charge, LaShonda. Okay, change the charge. Yeah, prosecutors are allowed to do that. Is it not beyond a reasonable doubt? That is the burden in this case. So Progress, you would be shocked at how often this happens. This has happened multiple times for cases in my firm within the last year. Literally. You'd be shocked at all this happens. And we pound the table, get so mad because there's nothing we can do. We have no leverage as defense attorneys when prosecutors do this. So this is not just this case. So Sean Barron, what would have been your closing argument if you were his lawyer? My closing argument would have focused a lot on consent, on the fact that they could leave whenever they wanted to, their ages at the time that they're talking about all this. None of them are underage now. When they say it happened when they were underage, can we really believe it's that many years ago? The timing on this, they can call a clinical psychologist and say that they are always going to go back and they're going to, not want to talk about it. But in reality, we're talking about a man's life and we're talking about beyond a reasonable doubt. Do you not have any doubts with how delayed this has been? And we're talking about 20 or 30 or plus years ago. That's what I really would have focused on is, did they really prove anything? And I would talk a lot about the fact that kinky sex and stuff like that you wouldn't agree with and maybe I wouldn't agree with, and a lot of us would say is immoral. A lot of times it's not illegal, and it's not illegal in this situation if they weren't minors, obviously, depending on which victim you're talking about and what time. But I would talk about a lot of it, how it's not how we would live our lives, and it may be the twilight zone, as some of the witnesses testified to, but it's not illegal. And it is. I would talk a lot about other RICO or racketeering cases. Be like, let me tell you about RICO cases. Let me tell you about racketeering cases, and just make them seem so opposite to this case. If the prosecutors had the right evidence, they would have just charged him with rape. If the prosecutors had the right evidence, they would have charged him with statutory rape. If they had the right evidence, it would have been sexual abuse. If the right evidence, they would have charged him with kidnapping. Not RICO. They're trying to fit a square peg into a round hole. That's kind of how I would have focused on it. Again, I'm not living in this case, so my closing argument would be much more detailed and smooth. This is just off the top of my head. That's the stuff I would focus on. That's the most powerful stuff to me, and I would really hit on the credibility of the victims. That's what I would hit on, as sad as it may sound. And again, this is me putting the hat on of the criminal defense. It doesn't mean that's actually what I think in this case or what I think is going to happen. So all the sauce, I need more specific info than this. Why didn't the defense use the stipulation thingy you mentioned that the prosecutors used for the cop? Give me a little bit more than that. Oh, you mean stipulate that the cop had committed perjury in the past, or forgery, I should say. So I think I'm just trying to read between the lines. So I think what you're talking about is the cop that testified, or the ex-cop that testified on behalf of R.Kelly, really didn't look good, I guess, when he was getting impeached and talking about how he did get convicted of felony forgery in the past. Why didn't they just stipulate to it, say, yeah, he's been convicted of a felony in the past? The answer is, if you're just convicted of a regular felony, you can stipulate to that, say, yes, I've been convicted of a felony, this many felonies, and that's the end of it. But if it's a crime of moral turpitude or dishonesty, as we say, like forgery, you're allowed to get into the actual facts of that, especially if he opens up the door, right? And that's what it sounded like he did in this case, because he said, oh, I left the police force on good terms. Honorably discharged, for lack of a better word. I know that doesn't actually happen in law enforcement. It's more a military term, but that's basically what he was saying. And they were saying, oh, really? So the fact that you used forged bills and were convicted of felony forgery had nothing to do with why you left the police department. So they kind of opened the door. That's why they weren't able to just kind of stick to a stipulation. So all the sauce. You know, I don't know about some of the language. I heard that they did do a little bit of this is the hip hop lifestyle kind of. They did do that in some of their cross examination. I don't know so much if they did it with the words daddy, but I mean, that seems like common knowledge to me that you don't just call your dad daddy. Like, I mean, that to me, that's not far above common sense. Jackie Burns, great point. And that's why we're not going to see any puns used in court, because the prosecutors would drive a truck through any pun that you use. And I think they may have, I haven't heard much of them using lyrics, but if I was the prosecutors, I would have used lyrics to a lot of his songs and put them in. Jackie Burns said, yeah, if you bump and grind on preteens/teens, there is something wrong with that. That's why he's in court. So New Chris, no, he can't sue the victims for financial restitution if found not guilty. I mean, he could try, but it wouldn't be successful. So Ton Bella, so are you saying the defense is comparing R. Kelly to Martin Luther King Jr.? Not the route I would have gone, but I don't know. I haven't seen the defense's closing yet, so I can't comment on it. Yeah, Dom, I actually don't think R. Kelly used the word escape, but I think one of the witnesses did. Obviously, a prosecution witness used the word escape probably for a reason, but I do think the word escape did come out. So Z, can you give more insight on mistrials and hung juries? So we've had some hung juries in the past, and it is miserable because you have to retry the case completely. Usually it does not feel like a win for the defense. However, in our case, after the hung jury, we got the charges reduced and dropped after a course was done, after a 5-day trial. So it would have been a bear to try again. So it ended up being positive for us, although it felt miserable at the time because the jury just deliberated for days and days. And we never knew what the count was, but we talked to some of the jurors after, and it was 5-1 as they started, and then it ended up being 3-3, and then 4-2, and it just kind of stayed as they could never get a consensus verdict. So, and that was just in our trial. So if you get a hung jury, you have to retry the case, and it goes back to the beginning basically with a new jury. If it's a mistrial, okay, so sometimes if the defense does something to cause a mistrial, the prosecution can tax costs. In civil cases, if there's a mistrial, the side that causes the mistrial sometimes has to pay fines and costs and sanctions for what they did if it rises to that level for them causing the mistrial. But in this case, a mistrial would just likely mean another trial to come. Unless the prosecution mistries the case, then there can be a double jeopardy element to where they cannot bring this case again. But if there's a hung jury, they can retry him for this. There's some nuance there. So you dig in me. Diane didn't say she used the word, she said someone else did. Yes, they did. They cleared it up. But if you're on the jury and you heard escape, like some of the commenters in here, and you're thinking escape sounds like somebody was, a lot of people, the problem, even with the transcripts, they read the transcripts as an echo chamber. They read them like they want to read them, and they find what they want to find in them. Because I've talked to people on both sides of this aisle who are free R. Kelly or are, burn R. Kelly, and they read the transcripts and say they're amazing for them. So the transcripts are not always black and white, even though they're literally black and white. Chocolate drop dropping as a law firm should. Thank you. Happy to clear up anything I can. So Nisha Mitchell, he is out if it's not guilty. Yes, he's out. If it's a hung jury or a mistrial, it's not going to be a mistrial at this point, I don't think, unless something unforeseen happens. But if it's a hung jury, he's likely to stay in. They can file motions to try to get him out and say, see, there's not that much evidence. There's not enough evidence to convict him, obviously. Let him get out. But my guess is if they already were having him in there, he's probably going to stay after a hung jury. So some people saying R. Kelly should have taken a plea deal. Sid J, prosecutors are boring. R. Kelly's lawyers seem to be more personable. And while some people may roll their eyes and say this comment doesn't matter, Sid could be a juror, and Sid could think that. we've had cases where people come up after and say, can I have your card? I'd want to hire you as a lawyer after. And are you telling me that that doesn't have an effect on the actual trial? That they liked you so much that they might want you to be their lawyer one day if they get in trouble or if they get in a car accident? That says a lot. And I do think the jury's feelings about the lawyer can come into play. Say aloud, is it harder or easier to defend a high-profile client? It really depends on the case and the evidence they have against them. I think that can cut both ways. We've had some high-profile clients where it's been really difficult. We've had some that have been much, much simpler and easier. So it really just depends on the case. So Ivan Franco, I don't know who you're speaking about particularly, but yes, if a lawyer messes up something or doesn't file something timely, it can be malpractice. But a lot of times in criminal cases, in order to win that kind of appeal, you have to show that what the lawyer did would have changed the outcome in the case. So Renee Mack, they can ask for recusal of the judge at any point where they think the judge should be recused or disqualified. I don't know if that motion had been, I didn't follow all the pleadings before the trial started, really jumped in. I mean, I knew it was going on just from the media, but we've jumped into the trial specifically. I don't know if they ever tried to disqualify this judge. Jackie Burns, could this case ever become the basis of a movie? Sure. It's already been a documentary. Movies have been made about much less interesting things. Nisha Mitchell, are you not for R. Kelly? You keep saying if. I don't know what I've said if to, but I'm not for R. Kelly. I'm not against R. Kelly. I'm just talking about how the evidence has come out in the case. If I was the prosecutor, how I'd act. If I was a defense attorney, how I'd act. That's where most of my comments come from. So Keisha, but how can they allow these witnesses when most of the alleged victims lied about their age and they were on the stand and confirmed they lied about their age? So it's strict liability for a statutory rape, right? So if I tell you I'm 18, but I'm really 15 and we have sex and you're an adult, that's statutory rape, even though I lied. So the fact that I lied doesn't change that. Now, if I'm the defense, I use stuff like, well, you lied back then. How are we supposed to believe you now? You can make arguments like that. So they're allowed to. And what they say is the judge will say, Mr. Defense Attorney, you can make that argument on cross and in your closing arguments. You just gave your answer. Thanks. Guilty. You said you would have convicted him. Think about that. Yeah, I said if I was the prosecutor, I think I could have had enough to convict him. Yes, that's what I said. I didn't say I would convict him as a juror based on this trial. So Shaw, baby, yes, the prosecution rested, I think, on Monday, and actually closing arguments are happening right now. The prosecution finished their first close at 12:30. The defense attorneys are closing right now, it seems. Adine Sadiq, how come you convicted? And I don't know what this is saying. I'm not saying I think he's getting convicted based on this trial. I haven't given that yet, what I think about that. I'm saying if I was the prosecutors, I think I would have had enough to convict him. I probably would have done it a little differently than they did it. Again, this is just guessing and speculation. I'm not saying that would have happened. People were asking me what I would do if I was the prosecutor or defense attorney. And this is what always happens. Nisha Mitchell, oh my gosh, free kills. I'm off this channel. You're for the prosecution. Y'all the same trying to take this man down. I'm really not. People are asking me what I would say. So Patricia Martin, do you think the prosecutor is being more towards the prosecutor or the defense? It seems like more biased. I don't want to say biased, but angling more helping the prosecutor, which is very normal and happens in most cases. So Secret Sister, to me, it sounds like an unperfectly scripted play with very bad actors. I've actually heard that. Too much hearsay, not enough evidence. Yeah, this was interesting. Say It Loud Radio. Good point. Why didn't the defense present a girlfriend that could speak in support of R. Kelly? That's true. I would have thought they would have, especially if you watched the Surviving R. Kelly documentary and they came out in his sport. Ashley Cashin. Yeah. So there's a big difference between a hung jury and not guilty. And Nia X, transcript is just one part of it. Well, they show the whole trial or most of it without the videos and some of the evidence, but they definitely don't tell the whole story. I agree with you there. So Elvira, in my world, people don't trust the judge either. I think we're kind of moving towards that where everybody's questioning everything. And I think the media has a lot to do with that too. You can't believe anything the media says. So Jessica Alter, it's not likely. Will we ever be able to see here that video that was presented to the jurors with him berating and supposedly hitting the women? Not likely. Jamie St. Peters. I guess I'm confused why the prosecutors didn't compare and contrast legit BDSM practices in the relationship to what R. Kelly was doing. I think that was purposeful. I think they just wanted all to sound bad, 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 illegal, convict this guy for this. I think that's what the prosecution was trying to do. How will this case impact his other cases? If he gets convicted here, um, some defendants will then plead in the other cases, but it doesn't seem like he's going to. It seems like he may appeal and keep fighting all of them. So we'll see. It doesn't necessarily affect the other cases. The other cases can just run as individual cases. Other people saying 100% guilty, 100% not guilty. So AW, can he sue the government for information released by a government worker, TK situation, when he gets out? Probably not. A lot of that can become public through the trial. His telephone calls and things like that. He didn't really have the same expectation of privacy, but he can sue, and it can't be defamation or anything like that because it wasn't untrue. But he'll probably try to do something, I would think. Miss Cece, I appreciate your viewpoint. I read Johnny Cochran's book and I listened to Tom Mesereau interviews. Defense attorneys are interesting. Thank you. T Hooks, would you be able to win this as a defense attorney? I would be confident. I think I'd be confident. Again, I don't want to give away what I'm going to say at the end of the video, but I would be confident in this case based on the evidence that I heard from the prosecution. I would be confident. I would be confident on either side. I mean, that's probably just goes to how I think about my skill. Hopefully people agree, but I would be confident as the defense attorney that there was enough to work with here. And seeing the victims in Surviving R. Kelly and hearing, a lot that you had to work with bias and impeachment, potential testimony, I would feel confident as the defense attorney that it would be a not guilty verdict or a hung jury. All right, Critical Thinker 8. As a juror, if I heard that they lied and I saw the parents' involvement, I definitely would not convict. Like, what in the world? See, this is the stuff that's interesting to me and important to me. So, like, as a juror, how would you think about the witnesses? How would you think about the situation, and why would you come to the verdict you came to? That's what I'm interested in. Correct. He has no burden of proof. Burden's on the prosecution. All right, let's see if we have any other questions here. Street exchanges, that's interesting too. Prosecutors trying to convict, they're not here to help the defendant. That's true, and a lot of people forget that. It's not the judge's job is not to help the defendant or the prosecutor, and the prosecutor's job is definitely not to help the defendant. Let's see here. Say It Loud Radio. If you go watch our Trevor Bauer videos, that's really interesting, and we kind of dig into this more in those videos. JD, because it's when you say leaning, like we don't know that, and it's probably impossible to prove that the judge is leaning that way. We're just speculating based on what we're seeing, that it just seems like the judge leans towards the prosecutor, but that is very common. A majority of judges were former prosecutors as lawyers. All right. Anything else? Albanian Anissa, glad you're catching the live. Donna Peebles thinks it's going to be a hung jury. Got some more not guilties. All right. So, yeah, so people are putting the octopus in. I saw something about somebody saying that R.Kelly was like the head of the octopus. Hey, Slider. So if you guys aren't subscribed to the page, please subscribe to our YouTube page. Because we're going to finish up the R.Kelly trial. This is probably our second to last video. We are going to come and talk about the verdict. I'm going to talk about what I think is going to happen, give my kind of educated guess. We've heard a lot from you guys on what you think is going to happen. So make sure you subscribe so you don't miss the last R.Kelly video talking about the verdict. I'm going to try to get on live as close to the verdict as I can, schedule permitting. But let me know what cases you want to hear about next, what trials you want to hear about next, and join our community by subscribing and liking this video. So when we talk about how these cases end, right? So it's got to, if the defense attorneys pounded the table on beyond a reasonable doubt, I think it's going to be really hard for them to convict. But I think so much has been piled on top of R.Kelly that I think it's going to be really hard for them to let him go back out on the street. So my guess is actually going to be the lowest. The whole time I've been leaning guilty, right? My guess would have been that they're going to convict him, right? And the reason for that is if you're just going by the percentages, if I was going to put money down, I'd put money on guilty, because 90+% of these federal trials end in a guilty verdict, right? So that's where the good money is on guilty. So if I was going to bet as a betting man, I'd bet guilty. But this feels like a hung jury. It just feels like a hung jury to me. There feels like enough on both sides. I think the hardest thing, though, and I think if it's not guilty, I think the jury did not believe the victim witnesses. I think the victim witnesses were not believable if it comes down as not guilty. And if it's guilty, I think the video and audio recordings that we didn't hear were so damning that a jury could not get over them, and therefore it's a guilty verdict, slam dunk, because we didn't get to hear those. That I think could have pushed him over the edge, which again is something that we can't know because we didn't see those videos or hear that. But the hung jury, right? So I can kind of see both sides really digging in hard, right? Kind of like our chat is. If this was our chat, it'd be a hung jury. I couldn't get 12 random people from our chat to agree, I think, after watching and hearing this trial and talking through these videos. So I think our chat would be a hung jury. So that's what I'm gonna speculate, that we're gonna get a hung jury, which would be crazy if we did, and very surprising and very unusual. Because like I said, most of these end in conviction. So I see a super chat here and a couple other questions I'll get to before we leave. I have not seen the movie 12 Angry Men, but that sounds like a recommendation So I'll try to get to it. All right. Can the government redirect and closing argument of the defense? They get a rebuttal at the end. Yeah, we talked about that a little bit at the beginning of the video. So Lauren S. agrees guilty. Well, he doesn't agree that he's guilty, but agrees it's going to be a hung jury. So Secret Sister, the prosecutors have a high conviction rate due to the high percentage of plea deals. They have a high conviction rate in trials in federal court, 90+%. Jessica Alter, why do you think he chose not to testify, and do you think that would have helped or hurt him? I'm gonna guess hurt him based on a lot of his public comments. I'm gonna guess that testifying would have hurt him. I think he didn't testify. Like I said in the beginning, there's two main reasons not to testify. Either, actually, I don't know if I said this or just wrote down a note about it, but the two main reasons to not testify are either you think the defendant's going to kill the case and you don't want him to get up there and ruin it, or you feel strong enough about how your case is going that you don't want to risk it, so you don't put him on the stand to testify because you think you've already won the case, right? And it can go either way. Secret Sister, I just answered one of your questions. And like I said, I'm trying to get to all of them. The chat kind of jumps around sometimes. Could you comment on my last post? I would love your input. I'm at the bottom of the chat now, so tell me what question you want me to answer, and I'll try to answer it before I go. I don't know where the other one is up in the scroll. So Nikki Bauman, do you think they proved this RICO? That's the hard thing. Where if I was a juror, I think I'd have a hard time saying that they actually proved this RICO, which is why I think it'll be a lot of emotion in there and not wanting to let this bad man back on the street. I think is kind of what the prosecution's theme has been, but we'll see. I'm giving it a couple more minutes if Secret Sister wants to put a question in, because I've tried to get to most of them. All right. Anybody else have any questions? Okay. I think if he testified, he would have been ripped apart like his last few public appearances. He's not seeming very smart. I don't know if he seemed very smart, but I think people have hated on him for a lot of his most recent public interviews. So Rufus Wilson, if they lie on the stand, is technically perjury. They can be prosecuted for it. They can be put in prison for it. Alana Johnson, I have seen that one. Runaway Jury. I'm always happy to get recommended legal movies. So Shamayim Israel. I've never seen a trial based off emotions. It's saddening. Literally, so many trials are based off of emotions, and lawyers for years have been playing on the emotions of cases and trials that we actually had to create jury instructions to instruct jurors to not let their emotions come into play when giving their verdict. It is so common that in every trial now the judge has to tell the jury they are not allowed to let their emotions in. So a lot of trials are based off emotions, but the sentiment is correct. It is saddening and shouldn't be the case. All right. So Albanian Anissa, I'm going to try to get on as quick as I can after the verdict comes down, which I expect to be early next week. Jackie Burns, I will. Now I will. I will watch 12 Angry Men. Albania Nisa, email us. We'll put our email in the chat. It's lawyeryouknow@gmail.com. Email us. We'll see if we can help you out. If not, we can direct you to somebody who can. So, sweet one. People are probably going to hate this. Based on your assessment overall, the testimonies and cross, do you think those women and former employees took advantage of him financially and used his dyslexia against him? No. I don't think he was taken advantage of. I don't. I have watched this and continue to follow it, Candy Cane. Very interesting. I did a podcast about it years and years ago. Incredibly interesting to me. And that prosecutor was a real peach. Makes you believe in karma, that you get what's coming to you for that prosecutor. Vessel, I do not practice employment law in Chicago, but if you email us, I can find you somebody who does, who can maybe help you out there. All right. That's a wrap for me. Thank you, everybody that came to the live. Make sure you subscribe so you can be in on the other cases and help choose the other cases that we break down and that we follow, like this video, because it just helps us out when you like it. And we'll be back after the verdict to talk about who was right, who was wrong, whether it was unfair, whether appeals are coming if he's convicted, or if it's a hung jury. We can talk about that too. But thanks for joining us. And as always, we'll just keep talking about it, right? Whatever happens, we'll keep talking about it.